Deacon.
Thank you, Chair. I have questions for both Professors Nesbitt and Martin, but let me start with Professor Martin. I'd like you to comment on what might be called the leading edge of sanctions debate in this country, in Canada. In some ways, we are trying to be at the leading edge and pushing the envelope. One is, of course, the recent bills to not only freeze and seize, but also to repurpose assets, not only under CIMA and Magnitsky, but also under FACFOA, which is really about legal agreements between countries. I'd like you to talk a bit about the problems of international law that you might see, Professor Martin, in this attempt to repurpose assets. The other area of the cutting edge in Canadian debates and sanctions is secondary sanctions, which I think Professor Nesbitt essentially is advocating or has alluded to. We are subject to secondary sanctions sometimes and try to block them. So I'd like you to comment on, again, the legality in international law. How problematic are these two ideas in Canadian sanctions thinking?
Thank you, Senator Wu. I think, the second, I'll start with the second question first, because I think it's a crucially important one. And in my report, I addressed this because there has been scholarship and policy advice, I think, within the Canadian discourse suggesting that Canada should engage in more secondary sanctions. And by secondary sanctions, just so everybody's clear, we're talking about sanctioning both third states, states other than the target state, and also entities and individuals within those third states as a way of deterring or preventing them from transacting with either individuals or the state itself, the target state. And as you allude to, Canada is very familiar with the concept of secondary sanctions because it's been the victim, right? And Canadian entities have been the victim of secondary sanctions in the form of the Helms-Burton Law, most famously, which sanctioned any entities or individuals who purported to engage in transactions with Cuba. Secondary sanctions are heavily criticized in international law and are argued to be unlawful under international law precisely because they violate international law principles on jurisdiction, and specifically principles that limit and constrain governments or states from engaging in the extraterritorial application or enforcement of domestic law, that is, prescribing laws to people outside of the territory of the state. And Canada, so far, has not engaged in secondary sanctions. And indeed, Canada, like a lot of European countries, have enacted laws to counteract the secondary sanctions of the United States. The United States is the most aggressive participant in secondary sanctions in the world. And countries have passed laws to counteract and to immunize their own individuals and entities from the operation of the secondary sanctions of the United States. In my view, it is a mistake for the Canadian government to contemplate becoming more aggressive or even to begin. So as I said, Canada has not so far engaged in secondary sanctions. I think that it should not. That would be my recommendation. I think I might be out of time, so I can perhaps come back to the freezing of assets question in the second round.